Good morning and welcome to the Shenkman Private Client Group Accountant Attorney Winter Webinar Series. This program is entitled Trust and Estates Litigation, Business Law Considerations. For those who don't know me, my name is Jonathan Shenkman, and I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer based in New York City. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between clients' attorneys, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You could read my work in Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. I always love to connect with attendees for my webinars. If you're interested in a call or Zoom meeting, or would like to share thoughts or feedback on my programs, feel free to reach out to me directly. I will include a contact information in the follow-up email to this program. Today, we're privileged to hear from Jeremy Stein, partner at Hartmann, Doherty, Rosa, Berman, and Bulbulia, based in Hackensack, New Jersey. Jeremy represents clients in trust and estate litigation, including will contests, actions for breach of fiduciary duty, trustee removal, and accounting proceedings. Jeremy also represents clients in complex commercial litigation, closely held business disputes, business divorce, business torts, class action defense, healthcare litigation, government investigations, white-collar prosecution, and restrictive covenant and employer matters. Jeremy works on a broad range of cases, including mid-sized litigations that often require flexible strategies in order to achieve the client's goals. Today, Jeremy will be speaking on trust and estates litigation, business law considerations. With that introduction, I'll now turn the program over to Jeremy.
Good morning. Thank you very much, Jonathan, and thank you for having me, and thank you for the introduction. As Jonathan said, my name is Jeremy Stein. I'm a litigation partner at Hartmann Doherty, focused on complex commercial litigation and trust and estates litigation. My firm is based in New Jersey, and I litigate in both New Jersey and New York. Our topic this morning is trust and estates litigation, business law considerations, and specifically the conflicts that arise between trust law and business law. So what kind of conflicts are we talking about? When I say conflicts between trust law and business law, what I have in mind is the different standards of conduct that govern actors in the business context, like corporate directors or managing members of LLCs, versus the standards that govern trustees of a trust. And for today, I'm actually going to narrow that down a bit more to focus in particular on the standards by which the law judges self-interested transactions undertaken by those two different groups of people. And we'll see that corporate law can be much more forgiving when it comes to self-interested transactions, whereas trust law is a lot less forgiving. And the reason I want to talk about this today is that these conflicts, these different roles, and the conflicts between the standards that govern them come up all the time, but often are not at all obvious. And that's because in the world of family businesses and closely held corporations, it's not at all uncommon for family members or others to be both managers of a company on the one hand, as well as trustees of a trust that own either all or a significant portion of that family company. And often I think lawyers and certainly clients don't appreciate these different roles, don't focus on them and the different duties that each of them has. And that can lead to some difficult planning questions. It can certainly lead to some complicated and scorched earth litigation and interesting litigation. But listen, everything I just said is abstract and maybe a little bit hard to follow. So let me tell you a story that brings this into focus. And this is actually a case that I recently litigated in federal court in the District of New Jersey and is now up on appeal to the Third Circuit. And in your handout, the first piece in your handout is actually a brief I wrote on the appeal to the Third Circuit. And if you want to take a look, flip through that brief while I'm talking, a lot of this is laid out in there. So here's the story. Back in the 60s or 70s, a man named William Jemison Sr. started a company with two partners. Mr. Jemison was the majority shareholder of this company. He owned about 70% of the company. As the years went on, the company did really well. Mr. Jemison made a lot of money. And as he got older, as many people in his position do, he started to look at succession planning so he could pass the company on to his children. So what did Mr. Jemison do? Mr. Jemison created an irrevocable trust. And he transferred the majority of the voting shares of the company into that trust, and he made himself the original trustee. Then to effect his planning, Mr. Jemison named all four of his children, Bill, Mike, Steve, and Susan, as the beneficiaries of that trust. But also, as part of his planning, he drafted the trust with a provision that provided that when Mr. Jemison died, all four of his children would become co-trustees of the trust as well as the beneficiaries, leaving them with equal control of this majority block of voting shares in the family company. Now, this was his plan on the ownership side of the company. On the management side of the company, though, things were less equal, a lot less equal with respect to the four Jemison siblings. Two of the children, Bill and Mike, worked for the company for many, many years, whereas Steve and Susan didn't work for the company. And as the years went on, and Mr. Jemison got older, Bill and Mike took over the company. Management transitioned almost entirely to the two of them. And most importantly for our story, when Mr. Jemison stepped down, the board was made up of Bill and Mike, the two older brothers, and Mr. Jemison's two other partners, the minority shareholders. The other two Jemison children, Steve and Susan, were not on the board. So then Mr. Jemison died, and this triggered the provision of the trust that made all four children trustees of the trust. So now at this point, what do we have? We have a family corporation, which is managed by two of the siblings on the one hand, Bill and Mike, who are on the board. But on the other hand, the majority shareholder of the company is a trust, and that trust is controlled by all four siblings and is held for the benefit of all four of those siblings. Now, this is not necessarily a particularly unusual situation in the family-owned context. It's not unusual in the family-owned business context for a subset of family members, a smaller subset of family members, to be managing and control of the company, while a much larger set of family members actually own the company. But as we all know, and TV, there are many TV shows, movies, and litigation, and I'm sure all of you have experienced this at one time or another in your professional lives. It's also a setup that can and often does lead to problems. And that's especially true when the family members don't get along, which was definitely the case here. As far as we can tell from the outside, Bill and Mike apparently did not care very much for their brother Stephen, and Stephen did not care very much for his brothers Bill and Mike. And their sister Sue, for her part, was mostly uninvolved. So this was a family dispute just waiting to happen. And not at all surprisingly, that's exactly what did happen. The two siblings who controlled the company, Bill and Mike, did all the kinds of things that minority shareholders or family members who are, to one degree or another, outside management absolutely hate. For instance, Bill and Mike paid themselves millions of dollars in bonus compensation that was well above and beyond sort of normal course of business compensation, even for a company that was making as much money as this company was. They also did things like take loans from the company to finance personal expenditures, buying personal real estate, and then they forgave the loans. That's always everybody's favorite. And then at the end, when it came time to wind the company down, Bill and Mike voted to sell the last remaining asset of the company, which was an operating unit, to Mike at a price that was far below market value. And Bill and Mike readily admit that they did that really for the reason that they wanted to give Mike's son, the next generation, the third generation, wanted to give him a job with benefits. So that's why they sold that piece of the company at the end to themselves. So Stephen, the brother who was not on the board, but was a trustee, filed a lawsuit challenging his brother's management of the company. And in that lawsuit, the parties said all the things you'd expect them to say. Stephen alleged on the one hand that his brothers were self-dealing and they were engaging in conflicted transactions, and that his brothers, Bill and Mike, breached their fiduciary duties, essentially by paying themselves millions and millions of dollars at the expense of Stephen and Sue. Bill and Mike, on the other hand, said what you'd expect them to say, which was that all of their actions were perfectly appropriate exercises of their discretion as directors, and that they built the company and they built the company into the profitable company that it was, and that they were entitled to all the compensation that they took. Now, from a corporate law perspective, we all know how this gets resolved, right? Courts are generally very hesitant to meddle in the internal affairs of corporations, even small ones. And the business judgment rule creates a rebuttable presumption that corporate directors' decisions are not to be disturbed or second-guessed unless there's some showing of fraud or self-dealing. Corporate statutes also expressly permit corporate directors to take certain self-interested transactions if they follow formalities or like creating appropriate subcommittees and the like. Corporate law also forgives directors for entering into self-interested transactions if in the end of the day, the transaction is fair. But here's the interesting question that this Jemison case in particular raised. Even though Bill and Mike were purporting to act in their capacities as corporate directors, the reality is that when they paid themselves those millions of dollars and when they sold themselves that asset of the company, they were acting in two capacities. Sure, they were acting as corporate directors, but they were also acting as trustees of a trust that owned the majority of the company and had the ability to control the company thereby, and was held for the benefit of two other people besides themselves, meaning their sister, Sue, and their brother, Stephen. And that means that not only were Bill and Mike bound by the standards that corporate trustees are held to, but they were also bound and held to the standards, or should be held to the standards, that trustees are governed by. And that meant that Steve had claims against his brothers, not only as directors, but also as trustees under trust law. So the question became, in this case, which law applies? Does the court say, well, this is just a typical corporate transaction, corporate case in which shareholders are displeased with the management of the company, and we apply the business judgment rule and the other business corporations acts provisions that permit these things in certain circumstances? Or do we apply trust law, which, as we're going to see, is a lot more restrictive? And this is an important question because, again, the standards really are qualitatively different. And let's take a look at that actually to see that the different standards. We're going to take a look at the statutes in New Jersey on point. And the reason I'm looking at the New Jersey statutes is because those were the statutes on point here in this case. But I'm also actually, for another good reason, looking at the New Jersey statutes because New Jersey is one of the states that has adopted a version of the Uniform Trust Code. The Uniform Trust Code was put together as a codification of a lot of the common law of trusts. And in several states, it's been adopted as the law, not so much supplanting the common law of trusts, but codifying it and supplementing it in certain ways. So to do this analysis, it's actually helpful to start with the corporate law before we look to trust law. So in New Jersey, the relevant statute is called the Business Corporations Act. And if you want to take a look at the first section, that's going to be relevant. It's in your handout at page 62. And the relevant section of the Business Corporation Act is NJSA 14A:6-8. It's in your materials. That act provides specifically with respect to self-interested transactions that, quote, no contract or other transaction between a corporation and one or more of its directors shall be void or voidable solely by reason of such common directorship or interest. So let's stop and think about what that means for a second. The Business Corporation Act in New Jersey specifically, explicitly provides that self-interested transactions are not void or voidable, and therefore are certainly not prohibited solely because they are self-interested. Now, yes, there are conditions on that, but the conditions are essentially that if the transaction is fair and reasonable to the corporation, then the transaction can stand. In other words, there is no breach of fiduciary duty on the corporate side, so long as the transaction is found to be fair and reasonable. And this would seem to make sense, right? There's no damage to the corporation. So who cares if the director is engaged in self-interested transactions? The Business Corporation Act also allows these transactions to go forward if the directors followed certain formalities, like setting up the appropriate subcommittees, and disclosed their interest in the transaction. So to be sure, corporate directors obviously have fiduciary duties to avoid self-interested transactions, but there are many escape hatches, a lot of, I don't want to call them loopholes, but there are a lot of release mechanisms that allow corporate directors to engage in these self-interested transactions. And the same actually is true under the New Jersey LLC Act. If you want to take a look at the relevant provision there, it's on page 63 of your handout. Same thing. It's really almost verbatim the same type of escape hatches. If it's fair, if it's disclosed, then these transactions can stand. And as long as there's no breach of duty if the LLC members follow those formalities. Now, under trust law, and specifically under the Uniform Trust Code, the standards imposed are completely different and much more restrictive. And we can see this in the workhorse provision of the UTC is section 55. It's at that's in page 59 of your PDF handout if you want to take a look. Section 55A, for instance, provides, and this is a quote, "A trustee shall administer the trust with undivided loyalty to and solely in the best interests of the beneficiaries, period," end quote. Full stop, right? There's no qualification, no fairness test, no permission to engage in self-interested transactions if there's if it's disclosed or if formalities are followed. The trustee is required to act in the best interest of the beneficiaries, period, full stop. This stands in significant contrast to what we just saw in the Business Corporations Act. And the UTC actually provides specifically that a transaction that is entered into, quote, for a trustee's own personal account or is otherwise affected by a conflict of interest is voidable by a beneficiary. So contrast that back to what we read in the Business Corporations Act. The Business Corporations Act said that self-interested transactions are not voidable solely because they're self-interested. The UTC, the Uniform Trust Code, on the other hand, says exactly the opposite. And sure, there are some exceptions in the UTC. It's not perfectly absolute, but none of the exceptions are, well, if it's fair to the trust, fair to the beneficiaries, then it's permissible. Or if the trustee disclosed their interest, then it's permissible. The UTC only carves out things like where there's an agreement between the trustee and the beneficiary, or where the beneficiary actually later ratifies the action. Those are the kinds of carve out, essentially where the beneficiary agrees and ratifies the trustee's self-interested transaction. Then the trust code says, okay, that's fine. But other than that, without the beneficiary's assent, trustees have very little wiggle room, if any wiggle room, to enter into self-interested transaction. Now, looking back at the Jemison case, some of you might be thinking to yourself, okay, trust law is more restrictive, but does trust law really apply to corporate actors just because they also happen to be trustees? Who says that trust law has any impact on corporate disputes? And of course, that's an entirely fair question, but this is where the UTC gets, I think, in my view, most interesting. There's an explicit provision of the UTC that answers this question directly. It's section 55F, and the UTC provides, quote, in voting shares of stock of a corporation or in exercising powers of control over similar interests in other forms of enterprise, the trustee shall act in the best interests of the beneficiaries and shall vote to elect or appoint directors or other managers who will manage the corporation or enterprise in the best interest of the beneficiaries. In other words, the UTC explicitly answers this question in the affirmative. Yes, trust law applies to directors who also happen to be trustees, and they are required under this statute in New Jersey. They are required to exercise their powers as directors for the benefit of the beneficiaries because they also are trustees of a trust. There's no escape hatch. There's no room for them to say, well, I'm acting in my capacity as a director, not in my capacity as a trustee, and therefore I have the ability to enter into a self-interested transaction if I comply with corporate law. So this is what the court was faced with in the Jemison case. And this is really the overlap and the conflicting roles that I was referring to at the start. We've got in the Jemison case what looks on its face like a run-of-the-mill corporate dispute. But really just under the surface, what we have is a trust case. And the question the court in the Jemison case had to answer was, do we hold directors to the standards that we hold all other directors to, or do we hold them to the higher standard that we hold trustees to? And as you can tell from my view, it seems to me that the UTC answers this question explicitly. But the trial court did not agree with my position. The trial court said what some of you might be thinking, which is that it just won't work, right? The district court held that even though the defendants were both corporate directors and trustees at the same time, their conduct was only going to be examined under corporate law and specifically the business judgment rule, and the court deferred to their judgment. The court put it this way, which is that to the extent the plaintiff is dissatisfied with the terms of the underlying deal, his dissatisfaction is with the decisions made by the corporation and the defendants, not in their capacity as trustees of the trust, but rather in their role as corporate officers. Plaintiff cannot simply sidestep the business judgment rule by arguing that defendants breached their duties as trustees. As such, the mere fact that defendants voted the trust shares to approve the sale does not establish a breach of fiduciary duty in their capacity as trustees. Essentially, the district court completely set aside that section 55F that says that trust law applies to corporate directors and said no, and said that was not to be taken into account, and corporate directors were free. Now, this is not the end of the story, and this is an important but, because this is not the end of the story. The Jemison case is the only case that I am aware of, and I have searched, and if anybody else can find one, I'd love to hear about it. Is the only case in which a court has directly addressed this question of what happens when you've got directors who are also trustees of a trust that owns the company. Which standard applies? This is the only case that applies this. So far, yes, the Jemison case, the district court, the trial court in the Jemison case said that we're going to set aside trust law and apply only corporate law, but that's just one case. And the Jemison case court is, of course, also a trial court. And of course, it's now up on appeal. So we don't know what the Third Circuit's going to do with this. Also, it's not like there's any analysis of this issue in the court's decision. The court really, the closest the court came was to say that it was, quote, untenable to take the position that corporate directors were going to be bound by these much higher, much more restrictive, corporate, trust standards. And of course, there's some intuitive appeal to the court's thinking, right? It would seem to be unfair or unworkable to have directors having to look over their shoulders as corporate directors, thinking, well, I'm also a trustee. What do I do, right? You're putting them in a somewhat, as the court said, an untenable position. But respectfully, I think the trial court got that wrong, because what one does when you find yourself in an untenable position like that is you've got to resign from one of those positions, right? The Jemison brothers could have said, well, I can't be both a corporate director and a trustee of the trust because my duties under these two schemes really seem to conflict with one another, so I can only carry on in one of those capacities. Just by way, just to bring you the most recent action on the case is, it's up on appeal. It's been fully briefed before the Third Circuit. The Third Circuit hasn't made a decision yet, but the Third Circuit did something that's actually kind of very unusual for an appeals court. After the full briefing cycle was completed, they directed the parties to file yet another set of briefs, pinpointing this question, answering the question of whether or not the transaction was conflicted under the terms of the UTC. So at the very least, while the district court, the trial court, has really sort of set that question aside, the Third Circuit at the very least is thinking about it, and we may get a very different decision. So where does that leave us? So here are a few closing thoughts. First, in the family-owned business and closely held business context, I think this overlap and this conflict comes up all the time. So I think for all of you estate planners out there and family business lawyers and the accountants as well, I bet if you take a look under the hood of your clients' businesses and their estate plans, I think that you're going to find in many circumstances that clients have these dual roles, both as managers of the family corporation, but also as trustees of a family trust. And there's going to be a conflict there. And what that means is there's a very real potential for that conflict and conflicting duties. And that is raises a serious concern on a prospective basis of disputes coming down the pike. Another point that I'd end with is that, I focused here on New Jersey law, but I think you'll find very similar conflicts under the common law, both in New York and elsewhere, as well as the New York Corporations Act as well, and the Delaware Act as well. I think if you compare generally the common law of trusts, not just in New Jersey under the UTC, but generally to the standards that are set out in the various states' corporate acts, you're going to find a very similar issue. So this is definitely not a New Jersey specific issue. And then last, just some practical tips and thoughts about this. On the planning side, I'll say this. I am very much a litigator, and I am very much not a trust and estates planning attorney. So I can't tell you what the solution is, and I certainly can't tell you what the most elegant solution is. But what I can tell you is that planners should be taking this into account when they are looking at, certainly when they're looking at succession plannings for multi-generational families. Just by way of example, what could Mr. Jemison have done differently? I think, for instance, he could have put in a different trustee, right? The children didn't need to be the trustees. They could have been the beneficiaries, but not the trustees. Could have put in another trusted family member who wasn't going to own the company. He could have used a corporate trustee. Of course, there's a give and take there in terms of control, but that's always the case when trying to avoid conflicts. And just as important for clients who may be past the planning stage, who already have these structures set up, but see a dispute brewing, right? Steve, when Bill and Mike saw that Steve was upset, what could they have done at that point before it all exploded into litigation? Of course, they had options. there are options there, including resignation from the trust or other techniques that they might have been able to use to avoid a conflict. The other practical tip is really with respect to litigation, and I'll say this is really fertile ground for litigation. The Uniform Trust Code is drafted in certain spots with a really extreme language. Trustees are required to act exclusively in the best interest of the beneficiaries, period, full stop. Those are the kinds of statutory provisions that litigators love to use. It's a great cudgel. You can use it to create leverage, to create claims where it can be difficult in the much more flexible standards of corporate law. And this is great stuff for litigators. And if you're representing a client who comes to you with a corporate dispute, it's really important to take a look to see whether or not there's also a trust aspect to it, because that can completely alter the trajectory of the litigation. And I think with that, I'm done. Thank you again to Jonathan for inviting me and for hosting these monthly events. And thank you all for coming. If anybody has any questions, wants to discuss any of these issues, please just look me up. Happy to talk. I'm sure my contact information will be in the email. Happy to chat anytime. Just shoot me an email, give me a call. Thank you very much.
Great. Thank you so much, Jeremy. If anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out to Jeremy directly or myself where appropriate. I'll be sure to include his contact information in the follow-up email to this program. One quick note, the handout was sent out along with the reminder email to this program. It will also be sent out in the follow-up email to this program tomorrow morning. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Two more quick items before I let you go. First, my next program and my first for my spring webinar series will be on Thursday, March 31st, on which entity structure is right for your client's business, featuring Avi Sinensky, counsel at Rifkin Radler, based in Uniondale, New York. Second, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance. And with that, this concludes today's session. Please stay safe, healthy, and have a wonderful day, everybody.